So if you're an attorney who refers clients to listing agents in California, I'm going to show you in this video why I believe you have to be involved and stay involved during the home sale process, or you have to put an attorney on your team who will, and why that attorney is entitled to at least, in my opinion, $10,000 for doing the work that has to be done on these files. Now, I think you could easily argue that you could be worth up to 50% of the listing agent's commissions, and there are methods that an attorney who doesn't pass the broker's exam who could do that. I've set up structures for in the past for attorneys who are getting allocations of foreclosures. I set up a structure so that they could receive 50% of the listing side commissions on every transaction. It was basically like owning a brokerage. That is a possibility, and I highly recommend you explore it. You can explore it with me or somebody else, but if you're doing a strong volume of sales, because sellers need to be protected, I think you should be looking to make 50% on these files. What I'm suggesting now is a starter for other attorneys who either don't have the experience or don't have a lot of files to refer, but have some. I'm suggesting 10K is a great place to start. 10K minimum is a great place to start. That's what this training is about. And that is what our consult that I'll offer to have with you is about when I get to that module. But from here, I could really start anywhere in this first column or anywhere in the second column. And the point of it all would be you'd want to work with an agent who could make the process work well, and your seller should be informed, and you are informed. So, I mean, it's really interwoven. But we'll start first with the mandate by suggesting this to you. The Realtor associations got sued for $1.6 billion because the listing agent was going in and negotiating for high commissions, keeping the commissions high, and buyers and sellers and other class action suits were very disgruntled with that process. Now, inside of that process, we saw the DOJ say that buyer agent commissions were causing steering, in that buyers were being steered away from properties who didn't pay customary buyer agent compensation and being stored those that did. That's still happening in spades, regardless of the changes. In fact, I'd say it's institutionalized and built into these forms. Because think about this. What happens when your seller gets an offer that requests 3% and your seller's like, well, I can see if I got full price, I'd pay 3%. But right now with this offer, $200,000 from where I want to be, there's no way I want to pay 3%. I'm at most paying 2%. And now your realtor has to talk to them about 2 or 3%. They're going to say, well, look, there's a risk. If we don't pay 3%, that buyer will have to walk. And why is that? Because that buyer signed a contract with your listing agent. We know they did because that was a rule before they even showed the property. And we know that the Realtor Association rule is that they have to reduce the amount that they're going to get paid to writing. They can't wait. So before they show the property, they're going in and asking for 2.5%, 3%. That's what realtors are trained to do. So if you counter to 2, there's a strong chance that buyer will have to walk, because that buyer has probably, when going through the forms, talking to their agent, said that I don't want to pay you any money out of my pocket. If I had extra money to pay you, instead of using it all up on the down payment, maybe I'd get better floors or buy a better house. So we know there's a strong chance if you counter below 3%, at least in the beginning of the file, that buyer will walk, because that buyer's agent has control of the transaction. They could lower it, but they don't have to, and they'll probably talk the buyer into walking. I mean, that's steering right there. It is there in spades. It's a shame that the forms have been set up that way, because steering has just been switched from the realtor brokerages to the seller. There's also compromising the fiduciary duty of the buyer's agent, and a subset of that is paying percentage-based compensations. Obviously, easily mitigated. Problem is, it's the third party's agent being paid by the opposing party, and they're paying them as a percentage, which means they're paying that agent more money if their buyer pays more. The DOJ brought that up as a problem with this system in the first memo to the court in the No-Select v. Pin case. So that's 2 risks, easily mitigated by attorneys after counseling to the seller. So that all comes together in these modules. The attorney understands it. The attorney explains liability. The attorney says, although there's no buyer agent compensation being offered on the MLS, we should start at zero, because we know your realtor is going to talk to you. You're going to ask them questions about buyer agent compensation. And, could you imagine when the realtor gets sued by a disgruntled buyer, they're saying, you were talking about buyer agent compensation? I thought you guys got sued. I thought it was illegal for you to talk about buyer agent compensation and keeping prices high. So, that's a mess. You want to reduce it to writing. I've got the forms in the process. It all works together in phase 1. I'll share that phase with attorneys that I'm working with. Phase 2, I sort of explained it. You want your seller to understand things. You're going to want to select an agent who will work well with you with the process. Really, the agent needs to represent your seller in a way that gives confidence to buyers so they make offers. And then the agent understands the process that we're going to use to try to have multiple offers to bring the price up and watch buyer agent commissions go down if there's more than one offer. But either way, your agent, all the special things agents do, what we want them to do is represent the process well and with integrity. It's very important if you're trying to get top prices for your home, especially now with the changes in buyer agent compensation. Listing attorney is my trademark. Maybe we'll come up with a name for you all if you want it. But the point is, you'll know what we need to know. And I also, if you have to come up to speed, I'll talk to you about that in the end. Now, I have a process that is very DOJ compliant. It's always worked well for sellers. It worked well for me earlier this year when we got 9 offers, and as the prices went up, buyer agent compensation comes down. So that's how I would recommend starting the first week. Of course, your sellers and your agent don't have to do that if they don't want to. But it's just the best process. It's the optimized way to do it, as long as your seller is willing to broadcast buyer agent compensation. And frankly, there's a reason why they would, and that's because by offering a consistent and broadcasting a level of buyer agent compensation, they're going to knock out suits that could come from protected classes that feel that inconsistent levels of buyer agent compensation could be discriminatory. So realtors can't broadcast buyer agent compensation, but sellers can, and sellers can do it without much risk if they know how to mitigate the risk, which is why you're helping out. Now, this counter language, I've got some videos on it out there. You may have seen them, but the point is realtors have to respond to the contract and request for buyer agent compensations in these 10 blank lines that they have to write in the language on the counter offer form. To me, it's absolutely crazy that realtors think that they can draft proper language protecting their sellers or mitigating the risks or anything related to buyer agent compensation. Well, let me just tell you why it's even more egregious. Because in the old days, on the forms, there was this, what I thought of even back then, as like a magic box. It was somehow magically within the contract, on the paper, but had nothing to do with the contract. And it was the part where the listing agent affirmed buyer agent commissions, which it had already sort of, the listing agent had to do on the MLS. When it was their money, they would put it on the MLS. That was supposedly a contract. And now this little box was affirming that offer and making that a contract between the buyer and the buyer's agent, presumably. But it had nothing to do with the contract. Yet lenders always wanted it all checked off and to look pretty. So it was just a magic box. It was in the contract, but not really in it. And now there's a form, a box G3, where there's a third-party beneficiary clause in the contract. But it really shouldn't be there. It should be part of a second contract, a contract for the price of the terms of the home. And just like in the old days, a separate contract for the amount of buyer agent commission. The seller will pay the buyer agent if they agree on price and terms. And it should be a separate contract. By doing it properly, an attorney can help their client get a higher price, has a very, very good chance of a higher net. It's almost guaranteed if you do this with bifurcating, you're going to get a higher net. I can't imagine that's the last round of negotiations, right? So anytime you're doing that, you've always got this chance for a higher price or a higher net. And early on, you're going to, you might not put the seller through a lot of hoops to mitigate the risks, but as negotiations go on, I think your seller might. So depending on your seller's risk aversion, you're going to use this bifurcated process to mitigate your seller's risks and help them sell for more money. All of this, super valuable, super logical. It matches together. And frankly, I think listing agents should be encouraging lawyers to be involved. In fact, they should have a disclaimer saying, if you're going to pay buyer agent compensation, you should first talk to an attorney. That in the end is how CAR is going to reconcile these problems, I believe, because they want to keep buyer agent commissions high. Their process is rigged to do it, and this needs to be disclosed to sellers, that the sellers are being exposed to risks when they do it, such as steering, compromising the fiduciary duty of the buyer's agent, keeping prices high, keeping buyer realtor commissions high. It's all built into the process. Now, getting paid. I've sold 200 homes as a broker. The California Association of Realtors has had me train realtors on two different things. One, on multiple offer negotiations, how to do it well, and back in the short sale days on how to negotiate short sales. I can tell you, this work, and in the past, negotiating short sales, lawyers and their negotiators could get a third. This work that you're doing is more valuable. Well, it's as valuable as that, and it's easily worth a third. Now, I don't know that lenders are going to agree to this every time, and I don't know that you all are ready to direct. I'm sure some of you are, actually. Some of you, I can speak. I can think of Arthur right now, who refers some files to me. He knows how real estate brokerage work. He can, when he sees this video, I'm going to call him up, ask him to watch it. I'm going to see what his reviews are, but I think Arthur already knows all of this, and some of you may know that. And in which case, I'd say go ahead, refer your clients to listing agents. Instead of asking for illegal kickbacks or something else, just go ahead and say, I want to get paid for the work I'm doing, right? I mean, it's so good. It's not a RESPA kickback. It's you're getting paid for the work. That it's also like State Bar doesn't want referrals. You're getting paid for the work. You're saying, I'm going to get paid for my work. So on the HUD, I want it there. Now, I'm going to say, I imagine, because even during short sales, some brokers had a problem with the short sale negotiating fees. Some brokers had a problem sometimes with my fees, which I sometimes ran through for doing the negotiations. I ran through my law firm when I was helping realtors outside my office. Sometimes lenders didn't like those fees. So I think you all need a backup. I can say when you're working with me, I guarantee I have no problem. They could take me to trial. I have no problem with a 10K referral to you. And I can also set up a structure that I did in the past for attorneys who got foreclosure allocations from the banks. I set up a structure that is bulletproof, that you will be entitled to whatever percentage we negotiate. So, it's there. I've done it in the past. We're there again. Interestingly, it's the foreclosure market is picking up in some states and prices are getting soft. And I think in part because realtors can't negotiate. They're not being able to broadcast buyer agent compensation to get multiple offers coming in. That's a side note. But if I'm the broker in San Diego or co-broker anywhere in the state, I'm going to make sure you get paid either on the HUD or out of my fees. If you're doing the work, I have zero problem quantifying how much it's worth and paying you. I want to pay you. I value your relationship with your client that much. So my name is John McConnin. You can set up a consult with me at listingattorney.com. You're probably right now wondering, well, how will that work? Well, for those of you that aren't 100% already locked in this, I have a pretty simple concept. If you have clients that you refer to listing agents, or even if you don't, if you want to pay the $3,000, I will train you for $3,000 as sort of a front against my future fees. So when I get those fees that I would be training you during the file anyway, I'll return that $3,000 as long as we set it up in a way that's RESPA compliant. But the point is that I've already sold houses and I've counseled my clients with all these things, and we've done the work. We brought in 9 offers. I got an authorization to make sure I could negotiate with the buyer and the buyer's agent about the fees. And, I didn't have to have an affiliated business disclosure or something similar, but I would suggest that you do. But, I'll have the process, and you can have me talk to you before you coach the client, and boom, we do that with disclosures. We do that with the counter. We do that with the seller liability and the zero BAC. Boom, it's $10,000 at least, probably more, depending on how much work you do and how much commissions are on the file. So that's really the program. I'm more than happy to return your fees against my work. I'm just doing the work ahead of time with you. When I get paid, I'll return the money to you. Let's say we do it within a year or just something so it's not crazy, like 10 years from now I'm retired and skiing and you're like, I need your help now. I mean, that's not going to happen. But we'll work that out. So go to listingattorney.com and set up a consult. I imagine, I haven't even thought about this, but if you're seeing this on Facebook, I suppose you could just type in consult, and I'll have to remember to set up a. I use Getting Clients Pro as my software. It's Go High Level, but I adapted it for attorneys and realtors. If you just type in consult in there, I'll make sure my AI quickly responds to you, and we set up a time, and maybe as soon as you do, the AI will set an alert up for me, and maybe while you're talking to it, I'll send the text and say I can talk now if you'd like, during business hours, obviously. My name is John McConnin. Listingattorney.com is my website. I am a broker and attorney in California. And if you're outside the state, I'd love to talk to you, especially the attorneys, about working with you. If you're a realtor and you're willing to pay an attorney to do it, let's talk. I mean, there's going to be some work involved, but we'll protect your sellers, and I know some of you are very interested in that. And we'll eventually put you in touch with local attorneys too, who become our clients. Thank you. Talk to you later. Bye.